Welcome to Tech Bytes and News, your daily roundup of articles featured in Hacker News. Today, we're diving into a huge victory for digital rights. A federal court ruling against backdoor searches of Section 702 data. It's a landmark decision.
Absolutely. I've been following this case for years. So, what exactly did the court rule?
In short, the court ruled that backdoor searches of Section 702 data, that's data collected under the Foreign Intelligence Surveillance Act, generally require a warrant. This is a massive win for privacy.
A warrant requirement? That seems obvious, but it's taken a long time to get here, right? The government has been doing this for years, hasn't it?
Exactly. This has been a decade-long battle. The government argued that since the data was already collected, searching it didn't require a separate warrant. They essentially had a finders keepers approach to our communications data.
Outrageous! So what was the specific case that led to this ruling?
The case was United States versus Hasbajrami. A U.S. resident was charged with supporting terrorism, and the evidence included emails collected under Section 702, then searched without a warrant. The court found that even if the initial collection was legal, the subsequent search violated the Fourth Amendment.
I see. So the court didn't challenge the legality of the initial data collection itself, just the subsequent searches? That's a nuanced point.
Precisely. The court acknowledged the complexities of Section 702, but drew a clear line on the warrant requirement for searches targeting U.S. persons. It's a significant limitation on government overreach.
And the sheer scale of these warrantless searches is staggering, isn't it? Millions of searches annually, according to the EFF. That's alarming.
Absolutely alarming. The ruling highlights the government's liberal use of Section 702, and the court explicitly rejected the government's foreign intelligence exception argument. They found the intrusion on privacy too significant.
So what's next? What impact will this have? What are the implications?
Well, the EFF is calling on Congress to refuse to renew Section 702 without significant reforms, including a mandatory warrant requirement for searches of U.S. person data. This is crucial, as Section 702 is set to expire in 2026.
And the FISC, the Foreign Intelligence Surveillance Court, should also act, right? They should update their rules to reflect this ruling. It's about time.
Absolutely. The FISC has a responsibility to ensure compliance with the Fourth Amendment. This ruling is a clear mandate for change. This is a huge step forward for privacy rights. But the fight isn't over yet. We need to keep pushing for transparency and accountability.
Couldn't agree more. This is a victory worth celebrating, but it underscores the ongoing need for vigilance in protecting our digital rights. Thanks for breaking this down for us.
My pleasure. And to our listeners, thank you for tuning in to Tech Bytes and News. We'll keep you updated on further developments in this important case. Have a great day, and remember to stay informed. Goodbye.
Bye-bye.